Ladies and gentlemen, I'm Chief Judge Jay Yukina of the 19th Judicial Circuit in Lake County, Illinois. Welcome to Your Courthouse at Work, where judges tell the story of how justice is administered in our county. In this episode, Treatment Court Judge Chris Stride reviews the very successful first annual Veterans and Family Services RUCK March held for the benefit of area veterans. In legal updates, Judge Veronica O'Malley will talk about the new e-filing requirements for orders of protection, and Judge Joe Salvi will update us on the law regarding companion animals in divorce cases. Judge Janelle Christensen will walk us through the Guardianship Help Desk with the assistance of our own probate judge, DJ Voderstrass. Judge Chuck Johnson will explain some of the new Illinois laws governing how bail is to be set in criminal cases. Judge Dan Jasica interviews Judge Ted Ponkoliak about what one might expect if they find themselves in small claims court. And finally, Judge Mike Foose will tell us about changes at the Lake County Courthouse. Stay tuned.
Hi, I'm Judge Chris Stride. I'm visiting today with Lake County Veterans and Family Services founder and president, Paul Baffico. Paul, how are you?
Thanks. I'm fine, Chris. Thank you.
We had a wonderful experience this past September. I was honored to participate in the first annual Lake County Veterans and Family Services RUCK March. Just what is a RUCK March, quickly?
It's an endurance march that the individual invests themselves in that they carry a pack and they walk a certain distance, and it's done to symbolize the agony of accomplishment. And in this particular case, it was also to bring the public's attention to the fact that we have far too many veteran suicides, as high as 22 per day, and now it's dropped a little bit to 20. And so they packed 22 pounds in the pack to symbolize the 22 deaths per day, and they walked 22 kilometers.
And this was the first ever RUCK March for your organization, is that correct?
Correct. It was the first. But we did have 122 people turn out, and we had 86 complete it, which we were astounded. It was a terrific spiritual success for the participants as well as people that were supporting us.
Your organization itself has so many different programs and vehicles to address the many complex needs of our fighting men and women coming back from our current conflicts and our older conflicts. If you could talk a little bit about that.
Our main objective is to connect veterans and their family members with each other, as well as with the benefits and the resources that they earned and deserve. Many veterans, and I'm one of them, when they come back, particularly from an overseas deployment in combat, they really do not want to engage. They want to be left alone. And with that comes isolation, depression, not necessarily PTSD, but your life is very different than it was. And so we try to teach people, both civilians and their families, as well as the service members, that this isn't just reintegration, it's a matter of renewing your life from a different perspective. And that is all centered on trust. We build trust with the individual because most vets, when they come back, have a hard time with trust. They have trusted the guy next to them or the gal next to them with their life, and they never experience that again.
If people are interested in either your organization or becoming a part of the RUCK March this upcoming fall, how can they contact you?
Our drop-in center is in Grays Lake at 100 South Atkinson, or they can call us at 847-986-4622. We're happy to talk to anybody.
And you're on the web as well, correct?
Yes, sir.
And what is that web address?
www.lakevetsfound.org.
Very well. Thanks again. It's been nice to visit with you.
E-filing is up and running at the Lake County Courthouse. Hello, I'm Judge Veronica O'Malley. In today's episode, I will be taking you to room D100 in courtroom 207 to learn about e-filing petitions for orders of protection.
And I am Judge Joseph Salvi. I will be providing you an update on the divorce law regarding companion or pets in divorce. And now let's begin with your interview.
We're here outside room D100, which is located around the corner from courtroom 207. Let's go in and meet with Ms. Damaris Lorta and her staff from A Safe Place. Hello, Ms. Lorta.
Hi, Judge.
Can you please tell us about the services A Safe Place provides in room D100?
We provide assistance with filing for domestic orders of protection, stalking no contact orders, and civil no contact orders. And as of January 1st, we also assist in e-filing all of these documents for the court.
Who's eligible for your services?
Individuals who are 18 years of age or older, who believe they are a victim of domestic violence, stalking, harassment, or sexual assault, or those individuals who are seeking on behalf of a minor child or a person with disability. The only other requirement that we have is that they must not be represented by an attorney on this case.
Now, are your services free to the public?
Yes, Judge. Safe Place Court Advocacy Program is free of charge to the public.
Can you please provide us with an overview of the steps involved in e-filing a request for an order of protection or these other no contact orders?
Absolutely. The first step is that they must come to the courthouse to request an order of protection. An order of protection is valid for up to 21 days. The person requesting the order is called the petitioner, and the person who the order is against is the respondent. We work with the petitioner in our office to obtain demographic information for A Safe Place. Then we do the necessary paperwork for the appropriate order and assist in electronically filing the petition for an order of protection. If the petitioner needs assistance in setting up an email account to meet the requirements for the e-filing, we assist with that as well. We then explain to the petitioner that there are 3 possible outcomes. The first one is that the emergency order is granted and the matter is set up to be continued for a hearing for a possible plenary order 2-year order of protection. The second thing that can happen is that the emergency is denied, but the matter is set for hearing on the plenary order or 2-year order within 21 days. Or lastly, the request for an order of protection is completely denied. On the plenary hearing date, we once again assist petitioners in preparing and e-filing all the necessary paperwork, and then we accompany them into court to provide emotional support and provide any necessary referrals. Please note that people can start the process from their home if it is safe to do so, and if they don't want our services, they can utilize the services of the law library and complete their order on their own.
So when is D100 open?
We are open Monday through Friday from 8:15 to 4:15. Due to the paperwork and the process, we do ask petitioners to be in our office by 3:15 to assure that we complete the whole process when they come in.
Thank you, Ms. Lorta, for the overview of this wonderful free service.
And thank you, Judge O'Malley. In recognition of the importance of the family pet, the Illinois State Legislature has enacted a new law in the Illinois Marriage and Dissolution of Marriage Act involving family pets or companion animals. In the past, pets were treated like any personal property of the marriage. Now, the court takes into consideration the well-being of the family pet in awarding ownership of the animal. This factor recognizes the importance of a pet within a family. And this has been Judge Joseph Salvi.
And I'm Judge Veronica O'Malley, reporting on Legal Updates.
Hi, my name's Judge Janelle Christensen, and I'm here at our Park City Courthouse to tell you a bit about the Guardianship Help Desk. Let's go inside and meet Probate Judge Donna Jo Vorderstrasse to talk more about the program.
Every Friday morning, the Minor Guardianship Help Desk serves 25 to 30 self-represented litigants. On an annual basis, the Help Desk assists between 1,300 to 1,500 cases. Navigating a guardianship case without an attorney can be very difficult. For families who cannot afford an attorney, the process can be overwhelming. These litigants are often nervous and confused. In 2010, the Lake County Bar Association, along with the 19th Judicial Circuit, recognized that there was a need to assist these families. The Guardianship Help Desk was launched that year and has been operating ever since. The volunteers at the Help Desk assist every self-represented litigant in completing the necessary forms, notices, and as of January 1st, 2018, even with the e-filing. More importantly, though, the volunteers help reduce the suffering of these families. Most of the self-represented litigants are only in court because a child needs someone in their life that is stable. For a variety of reasons, the parents are not able to care for the child. Many of the litigants are grandparents who were not expecting to raise young children again, but they respond to the need. The volunteers listen patiently to each story. They're kind and generous. They take the time to explain the forms and what will happen in the courtroom. The volunteers reduce the stress, the confusion, and the number of court appearances for the self-represented litigant. All volunteers for the Help Desk receive training from the 19th Judicial Circuit. Because the volunteers at the Help Desk do not give legal advice, paralegals are also eligible to volunteer. When the litigants finally appear before the judge with their completed paperwork, the judge has the time to focus on the family and to address their concerns. In other words, the assistance of the Minor Guardianship Help Desk allows for the efficient, timely, and compassionate administration of justice.
I really enjoy working with the people one-on-one, and I feel like I'm making a difference. I feel like I'm really helping them. I really do. Everybody's different when they walk in, but when they figure out that somebody's going to help them, everybody responds to that. I really like to see when sometimes the young people come in with them, teenagers. I think that that's probably the most touching response you get, is when you see somebody that's maybe not had such a good life until this point, and then they know that somebody's going to take care of them, and you get a little smile at the end, and it's very, very rewarding.
Coming into work at the Guardianship Help Desk has been really rewarding in that people are coming, and many of them have not had any contact with the court system before, and they don't know what to do. They don't know that they're the petitioner. And being able to help them and to teach along with helping them to make them feel more comfortable in the courthouse is really great. And to allow them to feel like they have some access and they don't need to necessarily have an attorney that's helping them through the process has been really helpful for them and for us.
Remember, the volunteers are here every Friday at the Guardianship Help Desk to help you. This has been Judge Christensen reporting from our Lake County Courthouse.
Hello, I'm Judge Chuck Johnson. Welcome back to Bond Court. Today, we're going to learn about a new state statute that greatly affects bail proceedings in criminal courtrooms. The Bail Reform Act of 2017, which was effective on January 1st of 2018, makes sweeping changes to the law regarding bail in criminal cases. This act was passed in response to what was felt to be inequitable bail conditions for certain defendants, especially poor defendants, who often had to sit in jail on relatively minor offenses because they were unable to pay even minimal bail amounts. The act contains several specific provisions. The presumption of non-monetary bail. Traditionally, bail has been understood to mean an amount of money posted to get out of jail. Since there has been a recent recognition that some people are sitting in jail simply because they can't afford to post even a minimal amount of bond on relatively minor crimes, the act requires the court to consider non-monetary, least restrictive conditions to assure the defendant's future court appearances and safeguard the public. These conditions can include curfew, no contact provisions, pretrial monitoring, and pretrial testing for drugs or alcohol. The right to appointed counsel The new law provides that the court can appoint the public defender's office to represent defendants at their bond hearings, even when non-indigent defendants may not have private counsel present to represent them. This allows all defendants of a certain level of legal protection for this important stage of the proceedings, while allowing them the opportunity to then hire private attorneys to represent them for later stages of the case. Second look bail hearings. The new statute creates two categories of offenses. Category A, which are serious felonies and violent misdemeanors, and Category B, which are lower level felonies and non-violent misdemeanors. Persons in custody for Category B offenses who are unable to post a monetary bond must be brought back to court within 7 days for the court to reconsider the amount of bond. This avoids the possibility of a defendant languishing in jail for an extended time just because they don't have the money for bond. As a practical matter, Lake County has been doing this on an informal basis for years. Bail credit for time served. Under the new statute, a person charged with a Category B offense gets $30 per day credit against their monetary bail for each day in custody. The statewide risk assessment tool. The legislature has encouraged the Supreme Court to adopt a standardized means of analysis for determining whether a defendant poses a risk of flight or reoffense. This helps eliminate wildly divergent bail amounts from jurisdiction to jurisdiction or even from judge to judge. Lake County has been in the forefront of this process using the standardized Virginia pretrial risk assessment instrument for many years to help predict pretrial failure risk as part of the overall judicial determination of bail. As you can see, the judicial system in Illinois is moving to a more standardized method of setting bail in criminal cases that takes into account the legal rights and socioeconomic situations of defendants while simultaneously protecting the community. Lake County has been utilizing many of these methods for years and will continue to be on the front lines of improvements to the legal system in the future.
I'd like to spend a few minutes introducing you to the Small Claims Division here at the Lake County Courthouse. In 2017, over 7,000 new small claims cases were filed. Many of those cases were filed by self-represented litigants, meaning people who did not have their own attorney. The Small Claims Division courtrooms are some of the busiest in Lake County, and they hear cases Monday through Friday at 9 in the morning and 1:30 in the afternoon. Let's go meet one of the small claims judges. I'm here with Judge Ted Piconiak, one of our judges who hears small claim cases. So tell me, what types of claims can properly be brought in a small claims court?
Small claims cases are cases where people are suing for money, small amounts, $10,000 and under.
And what should someone expect on the very first day that they show up in court?
Well, the first date is a return date. That's a date where to see whether or not the people that are being sued have been properly served with a copy of the summons and a copy of the complaint.
If on the first date the defendant denies or disputes that they owe any money to the plaintiff, what happens then?
I would instruct them that they would have to file an appearance. An appearance is a legal form that they have to file that brings them properly into the case, and then we would set a trial date anywhere from 2 to 4 weeks down the line.
So what should the parties expect and bring with them on a court date when it's set for trial?
Basically, they would bring in anything that they think they need to prove or disprove the facts in the case. It can be live witnesses, it might be documents, it could be pictures, it could be videotapes, anything that they believe would be, that they would think is necessary to prevail in their case.
And will the court consider anything that the parties bring in and try to present to the court?
Anything that's relevant. There's some items that are admissible, some that are not. Again, it depends on what they bring forward.
If the defendant shows up either at the return date or at the trial date and agrees that they owe some money or wants to try to work something out with the plaintiff, can they do that?
Yes. In fact, we're very open to having them try to settle it. I'll give them another court date and set it for status of settlement. And we would much rather have them settle it amicably versus go to trial.
Can you explain the small claims mediation program?
Right, it's a great program that we have here. It meets on Thursdays. There are mediators here that will sit down with the parties. If one of the parties is not represented by an attorney, there are volunteers here from the Lake County Bar Association that give up their time. They come in here, they sit down with the parties and try to work it out. We've got a great success rate of about 85% when the matters do go to mediation, because what you have is a trained individual who doesn't have a horse in the race, so to speak, and so the matters proceed completely different, and they do tend to get worked out.
And are there any other additional resources that are available to someone to help them explain the small claims process?
We've got a handbook for small claims. That handbook is also online now. And also down in the law library here in the main courthouse, there is a self-help desk where there's people there that will help them in the process too.
Thank you for helping explain the small claims process to us here in Lake County.
My pleasure.
Hello, I'm Judge Mike Foose, an Associate Judge of the 19th Judicial Circuit in Waukegan. One thing that's constant at the courthouse is change, and this past year has been no exception. 3 of our serving judges, representing more than 55 years of combined experience on the bench, retired in December 2017 and January 2018. Former Chief Judge Margaret Mullen of Lake Bluff was first appointed in 1992 and served over 25 years as a leader in virtually every division in the Lake County court system. In addition to being a highly respected civil, pretrial, and trial judge, she was highly admired for her detailed knowledge of both substantive and procedural law. Judge Mullen was an invaluable mentor to many colleagues and was also widely recognized for her leadership and service to nonprofit organizations and civic groups. She also worked to improve judicial excellence by serving as president of the Illinois Judges Foundation and as a contributor and lecturer at the Illinois Judicial Education Conference. Associate Judge Brian Hughes of Antioch retired after more than 17 years on the bench. Following his graduation from John Marshall Law School, Judge Hughes represented indigent clients as an assistant public defender and then was in private practice. Judge Hughes primarily served in the juvenile, traffic, and misdemeanor court divisions and was highly respected for his patience, humility, leadership, and sense of fairness. The Honorable Nancy Schuster Waits of Mundelein went to law school at night and actually taught high school for 7 years before becoming a lawyer. She served as a judge for nearly 13 years following a distinguished legal career, and her wisdom, compassion, and love for people made her the ideal judge for handling complicated and emotional family, juvenile, and probate cases with both grace and sensitivity. She also distinguished herself through her commitment to helping the indigent obtain necessary legal services and her dedication to professional and community organizations. In January 2018, Associate Judge Joseph Salvi of Hawthorne Woods was appointed Circuit Court Judge by the Illinois Supreme Court to fill the vacancy left by Judge Mullen's retirement. Judge Salvi earned his Juris Doctorate degree from IIT, Chicago-Kent College of Law in 1991, and practiced law with the Lake Zurich firm of Salvi, and Whiffler for 22 years before being appointed Associate Judge in Lake County in 2013. Judge Salvi, who is currently assigned to the Family Division, is also very active in bar associations and local youth groups, community sports and nonprofit groups, especially those that assist needy families. 2 of our new associate judges, filling the vacancies left by Judge Hughes and Judge Waits, are Stephen DeRue of Antioch and Jacqueline Melius of Libertyville. After earning a Juris Doctorate degree from the University of Illinois, Stephen DeRue of Antioch was appointed as an Assistant State's Attorney in Lake County. While there, he prosecuted criminal cases in nearly every division of the office, eventually becoming Chief of the Domestic Violence Division. His wide experience handling high-profile criminal prosecutions will serve him well in his new career as a trial judge. After graduating from Northwestern University, Judge Melius of Libertyville taught high school before entering John Marshall Law School. After passing the bar, she joined a Libertyville law firm where she handled serious personal injury cases for 18 years, rising to partnership. Her hard work and dedication to clients helped establish her reputation as an outstanding trial lawyer, as well as a leader in local bar and professional legal organizations. Our newest associate judge, Ari Fiz of Deerfield, was sworn in on March 16, 2018, to fill the vacancy created by the appointment of Judge Joseph Salve. After graduating from the University of Illinois College of Law, Judge Fiz was in private practice before joining the Lake County State's Attorney's Office. And in his more than 15 years as a criminal prosecutor, he handled the most serious felony cases and also served as chief of the Felony Review and Felony Trial Divisions. Judge Fiz spends much of his personal time talking to high school students about the dangers of underage drinking and drug use. Although several experienced judges have moved on, the newest Lake County judges are well equipped to continue the important mission of our American justice system. That is, to ensure that everyone, regardless of age, sex, race, religion, color, or economic status, is afforded open and fair access to the courts for resolution of their disputes. And that is true justice under the law. I'm Judge Mike Foose. Thank you.
We hope you enjoyed this episode of Your Courthouse at Work. All of us in the 19th Judicial Circuit strive to serve the people of Lake County with integrity and competence, and in a way that makes every citizen confident in their judicial system. I hope this segment has been informative and has shown you a bit about what goes on at the Lake County Courthouse. From the 19th Judicial Circuit in Waukegan, Illinois, I am Chief Judge Jay Yukonow, and I thank you for watching.